Good afternoon, everybody, on today's PACE webinar. We're here to discuss what has happened with the FCC with Commissioner Wheeler's comments. This is Stuart Discount. I'm the chairman of the Government Affairs Committee for PACE. And before I introduce our speakers today to explain it, we have 30 minutes. We have another seminar after this. It was pre-scheduled for the compliance certification program. If you have any questions, please type them in the box and we'll try to get to them if we have time. And this webinar will actually be recorded and it will be posted on the website, the PACE website, in a couple of days. So I just want you to know that PACE has taken these comments very seriously. We plan on developing a strategy to represent our members and make sure that we voice our opinions. And today you'll hear exactly some background and some ideas, but we will need our membership to help us out. So without further ado, I'm going to introduce Michelle Schuster and Nick Whistler, who will take you through the presentation. Michelle's our legal counsel for PACE, and I'm sure you all know her, and Nick. So go ahead, Michelle.
Thanks, Stuart, and thanks, everybody, for hopping on the phone today so that we can talk about what happened last week, what the likely outcome is as a result of the announcement last week, and to start talking about the types of things that PACE plans to do as we find out what exactly it is that the FCC will be doing later this month, how it's going to affect our industry, and whatever issues result as a matter or happen as a result of those actions. You know, this is an issue that all of us on the phone have been dealing with for a long time now. We have an agenda today where we're going to talk about exactly what matters have been pending in front of the FCC. PACE has been at the forefront of filings with the FCC around recent changes to the TCPA, and we plan to continue to be in the front of these issues as we move forward. We're going to go into detail about what it was that was contained on the fact sheet that was released by Chairman Wheeler last week, and then what the likely outcomes are as a result of what was said in that fact sheet. So let's start with a little bit of history here. You know, it goes back further than 2012, but for procedure purposes and for what we're looking at as far as likely outcome with the FCC later this month, it all really started in February of 2012, and immediately preceding that. As you recall, back in February of 2012, the FCC released its intended ruling on all of the changes, primarily around cell phones, but as you recall, it was also around pre-recorded messages and also abandoned call messages and automatic opt-outs that needed to be contained in those abandoned call messages. So it was very broad, but I think the primary impact for our industry was around calls to cell phones and the additional consent requirements for calls to cell phones. Nick's going to go over what we did as an association in response to that notice of rulemaking that was released by the FCC back in 2012. And even prior to 2012, when we were still the ATA was filing comments in response to requests for comments from the FCC around what was going to likely be that ruling. So the history goes back a long way with the association. Those rules that were announced on February 15th through 2012 obviously went into effect on October 16th, 2013. And as a result of that, we are all aware of the hundreds of consumer actions and consumer class actions that have been filed around calls to cell phones. So this has been a very hot issue for our association, for the members, and a painful issue in a lot of ways as a result of a lack of clarity around those rules that were released in 2013. To make matters worse, not only did we have lack of clarity with the rules that were released and what constituted an automatic telephone dialing system, we also had courts throughout the United States that started issuing differing opinions around the definitions of what constitutes an automatic telephone dialing system, and also, what type of consent is required if you're going to call cell phones. And in the interest of time, I'm assuming that everybody is aware of the prohibitions of the TCPA, but I guess I should stop for a second and just say that we're talking about the prohibition against using an automatic telephone dialing system to call cell phones, and what that definition of an automatic telephone dialing system is. On top of the differing court opinions, we've had FCC enforcement actions and also staff opinions that haven't provided a tremendous amount of clarity in this area. And we have dozens of petitions that have been filed with the FCC that are pending still that asked for clarity around these issues. So that's the history that brings us up to where we are right now, and what we think likely will be the outcome of the FCC's commission meeting on June 18th. So with that, I want Nick to go into a little bit more specificity around what PACE has done to be involved with this issue in the past to kind of bring you up to speed.
Thanks, Michelle. So prior to the actual rule changes that were adopted in 2012, PACE, back when it was still operating as the ATA, filed comments, as Michelle mentioned, in response to the FCC's request for comments. And, by and large, one of the main underlying principles there was that ATA, now PACE, opposed any significant restrictions on calls to cell phones beyond what were already in place. So, the focus really was on businesses should be able to contact their existing customers on their cell phones, and that was prior to the proposed rule changes. Once the FCC adopted those changes and published those in February 2012, PACE filed a petition for reconsideration in July of that year. So there was a few different asks in that petition. The first dealt with that automated opt-out, and it was largely procedural. They hadn't provided notice of that particular change up front, and so PACE was challenging that. But really at the heart of the issue is the ATDS definition and the written consent requirement. So a significant portion of that petition focused on prior FCC rulings that held a predictive dialer was an ATDS, and in doing so, they kind of, extended the statutory definition beyond what was, originally intended by Congress. So we were opposed to that and asking for some, clarification that that's not really what they meant, that all predictive dialers are an ATDS, but only in certain situations. We also challenged their specific written consent requirements. So one of the things that many of you know is that it's not sufficient just to get consent to call somebody. You have to have consent to call them using an auto dialer. You have to disclose that consent is not required as a condition of purchase, and we felt those were overly burdensome and requested some clarification on those issues. Moving forward, in October of 2013, when the rule was set to take effect, we kind of decided we needed a backup plan. If we couldn't get them to back off of the predictive dialer ruling, we needed at least some relief from them. And what we wanted was them to at least, at a bare minimum, clarify that equipment is not an ATDS if it didn't have the current capacity to dial without human intervention. And so this would provide some clarity that these manual dialing systems that everybody's been turning to are, in fact, compliant with the TCPA, and we didn't need to worry about these written consent requirements, and we didn't need to worry about the class action lawsuits that were so prolific. In addition to that, PACE has also filed comments in response to various petitions filed by other businesses, other associations. The one that's on the slide here was filed in support of an ACA petition, and it again deals with the ATDS issue and the predictive dialer component of that. It has some comments supporting some type of safe harbor or relief for calls made to a reassigned number. So lots of businesses have been held responsible for calls that would have been compliant had the number not been reassigned from the intended recipient to the actual recipient. So we supported relief from that type of unknowing violation. And the last issue addressed in there had to do with calls of VoIP numbers, and if you didn't know that the person was going to be charged for that number, there should be no responsibility under the TCPA for those calls. So it kind of gives you a flavor for some of the other types of comments that PACE has been filing on this issue over the last handful of years.
So as you can tell, we've put lots of information in front of the FCC around what we think are the issues that have affected the industry and hopefully providing guidance to the FCC around the issues that we believe need clarification. I'm hopeful that as a result of what's filed and meetings that PACE has been involved with the FCC, which if you're interested in any of those meetings, when you have a meeting with the FCC, you're required to file an ex parte communication notice, and all of those are online at the FCC. So all of this is just to say that the industry voice has been there, and the FCC has heard, hopefully, the industry voice, and that in some way is going to be incorporated in what's going to be released on June 18th. So what do we have foreshadowing what's going to happen on June 18th? We have from FCC Chairman Wheeler a fact sheet that was released last Wednesday. Onto the right column of the slide you're looking at now is the first page of that fact sheet. It's very short. It's a 2-page document. I'm going to go into details about what that document says, but I will tell you it's very much consumer protection focused. It has what I would label as a lot of consumer protection rhetoric contained within it, and it's obvious that the FCC is pursuing this from the consumer protection standpoint. You can get a copy of the fact sheet at the URL that I have listed there, or you can Google FCC TCPA Wheeler fact sheet, and it will pull up the fact sheet as well as dozens of articles that have been written about it over the last week. At the heart of the fact sheet, what it does is it puts all of us on notice that at the June 18th hearing of the meeting of the Commission, they plan to vote on a declaratory ruling. And what a declaratory ruling is it's the Commission interpreting its statute, and here the TCPA, so that it clarifies how that regulation is to be interpreted and enforced. The declaratory ruling says that, or the fact sheet says that the declaratory ruling is in response to over 24 petitions that have been filed with the Commission on various issues, which I'm going to go into here in just a moment. It is almost for certain that this declaratory ruling will be approved and passed by the FCC, and it will be passed in such a way that not individual provisions of this declaratory ruling will be addressed, but rather it will be passed as one whole document. So while there may be some discussion by the Commission during that meeting, I think it's highly unlikely that there will be much discussion. I think that 2 of the commissioners will likely dissent on the declaratory ruling, and we might have those commissioners putting their comments on the public record. We'll probably likely also have comments by commissioners that will be supporting and voting to pass or voting in favor of enactment of the declaratory ruling. Once the declaratory ruling is approved, then the interpretation that declaratory ruling espouses is what will then be the law, for all intents and purposes, on how the TCPA will be interpreted. So it would be very difficult to have any ruling that was contrary to what the FCC's petition is in this declaratory ruling. There's a statute that I'm sure you've heard Nick and I talk about that has been used to overturn some of the more out there court rulings that have gone against what the FCC has said about what constitutes, for instance, express written consent, that have been overturned based on that Hobbs Act. So this declaratory ruling will have the effect of law. Now, we'll talk about some outcomes that are possible as a result of this ruling, and that would be through either requests for reconsideration or appellate procedures through the courts. But absent something happening in that arena, this declaratory ruling will have the effect of law.
Michelle, there is a question about when we have to comply, and this is immediate.
It will be immediate. Because what a declaratory ruling does is it looks at the statute and it says this is what that statute means. And we had a declaratory ruling back starting in 2003 and then 2008 around what constituted an ATDS, and the FCC said that a predictive dialer functions like a random or sequential dialer. Therefore, a predictive dialer is an ATDS. So that's an example of a previous ruling, and that had effect at the point where the ruling was approved. So it would start immediately on June 18th. And has the potential, too, of influencing courts that have cases pending. Depending upon what the FCC does and exactly what that declaratory ruling does, it will have the effect of influencing courts that are currently hearing cases because the FCC is interpreting that statute. So very significant outcomes as a result of what happens with this vote on June 18th by the FCC. So what did Chairman Wheeler say on his fact sheet? And I thought I'd just kind of start with the rhetoric because I think it foreshadows what we are seeing as far as what that declaratory ruling will be. And I should tell you that the fact sheet says that the declaratory ruling is currently being circulated among the commissioners and their staff. So whatever is going to be drafted has been drafted at this point. I assume that the Commission has spent a significant amount of time talking already about what's contained in that declaratory ruling. I think it highly unlikely that there would be much influence at this point in changing what that declaratory ruling says, especially in light of the fact sheet being released last week. So I've gotten lots of questions about what can we do between now and June 18th, and I'll tell you there's not a whole lot to do. It would be great to be able to get a copy of this declaratory ruling that's being circulated with the FCC, but I think that highly unlikely that that will happen before June 18th. So the stated purpose of the declaratory ruling will be to protect Americans from unwanted robocalls, spam text messages, and telemarketing calls. So very much from a consumer protection standpoint and limiting the type of unwanted calls that consumers would get. You know, it's interesting, and Nick, you and I have talked about this, the term robocall being tossed around. Nowhere is the term robocall defined in any law or regulation. I often wonder when the FCC throws out robocall if they mean any kind of call with a predictive dialer or whether they're only talking about pre-recorded messages, which is how we in the industry would interpret that. Yeah,
I think they actually do. They use it interchangeably to talk about pre-recorded messages and calls made using an ATDS, and the distinction between those two types of calls is very important because some rules don't apply to calls made using an ATDS, but would apply to a pre-recorded message. So I think they're doing everybody a disservice and really not fostering clarity by using that term because that just seems to be what consumers want to hear is robocall.
Right. Well, it'll be interesting. Hopefully the declaratory ruling doesn't use that term. If they do use it, they define it because it is not defined. It's one of those terms that's definitely more rhetoric than anything else. The fact sheet also said that the declaratory ruling is going to address 24 petitions that sought clarity on how the Commission enforces the TCPA. So that's what I was talking about as far as clarifying terms within the TCPA. I would be shocked if PACE's petition for a declaratory ruling was not one of those 24 that was considered in here. So I would suspect that there'll be mention of our petition in that declaratory ruling. The ruling also seeks to close what they consider loopholes and strengthen consumer protections already on the books. We'll talk about what we assume that to mean. And then also, they have said that this will be one of the most significant FCC consumer protection actions since it established the Do Not Call registry. So that's why we are very proactively looking at what is likely to happen and how we can respond to that. So what is the clarity that the FCC has said that they're going to be providing in this declaratory ruling? First, they specifically said that they wanted to ensure that the courts, consumers, and industry knew that the right to revoke consent, the consent to receive either a pre-recorded message or a call on your cell phone using an ATDS, that you can revoke that through any method or through any reasonable method. And it's not just limited to the method the consent was provided. There's been some court opinions that have led, I think, to confusion about how you can revoke consent once it's provided. It's obvious the FCC is going to make that very easy for consumers to revoke consent at any point in time. Also, and this is interesting because I don't know if you guys recall, about 2 years ago, the FTC put out a bounty for anybody who could come up with technology that would stop pre-recorded messages. And I'm not sure that there was ever any great solution that came out of that. There hasn't been anything that's been put in widespread use, but I know that there was an award of a $50,000 bounty to at least one person who had a proposal under that FTC announcement. But what the FCC is saying is that if there is robocall blocking technology, again, I don't know if that's any phone call using a predictive dialer or if it's only pre-recorded messages, but that the FCC would allow telecoms to use that blocking technology to block calls to consumers upon request. So that will be interesting to see how that progresses. Also, they have said, and this was, I guess, a pro-industry move, that you can make calls without consent, either pre-recorded messages or calls to cell phones using an ATDS in emergency situations. The type of examples that they gave for that was
bank fraud.
Yeah, fraud announcements, or also important medication refill reminders. But not, they specifically said, but not for telemarketing and not for debt collection. So there is an exception to the consent requirements for emergency calls. And then probably most interesting for us is that they also, Chairman Wheeler also said that the definition of an ATDS would have clarity after this declaratory ruling. But he also said that it means that dialers with the current capacity and actual use or its present capacity. So looking at predictive dialers, we hope in current capacity, but it certainly doesn't say that. And interestingly enough, in one of the statements that's contained on the fact sheet, they were defining an ATDS as something that dialed from a list. That was the term that they used. So that language was a little bit concerning. One thing that wasn't on this slide, and I apologize in the haste of putting it together, but it speaks to what Nick had talked about with the ACA petition that we supported. The ACA had sought clarity around reassigned phone numbers and whether it was a violation to call a reassigned phone number. And it appears that the FCC is going to say you can make one phone call before having liability for a reassigned number. The fact sheet doesn't say, though, that the consumer has to notify the calling party that it's a reassigned number. So, again, hopefully the declaratory ruling will have more information around it than just one phone call. So I think we've already spoke to what's on this next slide and what's next and what's likely to happen on June 18th, and that we are going to have a declaratory ruling. It will be effective immediately. And that PACE will be looking at all of its options once we receive that declaratory ruling. It's very critical, though, at this point that we have member support around this issue, and I would very much appreciate that as this situation evolves and as you start to study how the declaratory ruling is going to affect you, that you share that information with PACE and with Nick and I, because when we talk to the Commission and when we look at any avenue possible after June 18th, what we have that other associations and other parties that are involved with these issues don't have is we have the industry, and you guys are the industry, and we are that industry voice. So it's very critical that we understand how these issues are affecting you in terms of decreased sales and loss of competitive edge as far as in comparison with international companies and other issues of that like. So please share that information. Stuart, who's the head of our Government Affairs Committee, is at the forefront of these issues, so he most certainly will want your input and feedback as this issue progresses. I see we have lots of questions, so let's leave these last couple of minutes at the end. We have 4 minutes before our next webinar that I encourage you to stay on starts. But Stuart, are there any questions you want to bring forward?
Yeah, there's a couple questions. One is, has there ever been a successful challenge to the FCC rule, any rule at the U.S. Circuit Court that you know of?
Well, that's a good question. So, you know, my area that I focus on, that we focus on, is really only in the telecommunications. So the FCC has a much broader mission than what we look at. I'm sure there has been. I'm not aware of that. With regard to what we've seen in the TCPA in recent history, I can't think of any. I don't think there has been. But I'm sure in any of the other missions there's probably been, especially in the telecom and licensing regulation area, there has been.
Next question was, since no consent is required by non-commercial pre-recorded messages to a home phone, how can the FCC require opt-outs?
Can you repeat that again, Stuart?
Since no consent is required by a non-commercial pre-recorded message to a home phone, how can the FCC require opt-outs?
So they don't for a non-telemarketing call. The opt-out requirements that they put into place for pre-recorded messages only apply to telemarketing calls or calls made to a cell phone, which would also require an opt-out.
Okay. Next one, I think you've probably been answered. Is there we don't have any hints to include and dial without human intervention. There's been no language on what the clarification is going to be yet, right? That we don't know anything.
We only know that it's going to deal with those subject areas that I talked about, and we can suspect from the consumer rhetoric that it will be consumer-friendly and not industry-friendly, but we don't know. No one I know, nor have we seen that declaratory ruling that's being circulated.
What I would say to that also is that I think it's pretty clear when they talk about dialing from lists of numbers that they're not going to budge on the the predictive dialer rulings that they've made, but they haven't tipped their hand at all in terms of how they're going to address what is capacity and whether it's, capacity, current capacity or future capacity.
And the last was a comment or a question. If robocall blocking technology is implemented, wouldn't this make using ATDS for service calls a big challenge? And I think the answer is yes.
Yeah. Yep. Absolutely.
And that's all the questions. So unless anybody wants to type something real quick.
Stuart, and I'm sure you would agree with this, I'm certain that we will have a webinar very shortly after the June 18th release. We'll probably have something on the 19th. We should probably start scheduling that now so that we can have the 18th to digest what's in that declaratory ruling, and then we can bring to members what it says.
And we'll still provide information on the website about our plans and our strategy as we move forward and comments from our council. So.
That's right. That's right.
So, Michelle and Nick, thank you very much.
Thank you. Thank everybody for attending and staying in tune with this issue.
There is another question. So robocall blocking technology would block ATDS calls?
Yeah, I don't know. It's a really good question. I think it's the Consumer Union has been raising funds to lobby on this issue for a long time. I think the state AGs also issued something asking the FCC to allow this blocking technology for certain types of telemarketing calls. There is no technology that I'm aware of right now out there that would do that. Speaking to Dean Garfinkel, who's on our executive committee and very knowledgeable of dialers, he's not aware of any either. But what this would do, I'm sure, would be motivate a whole industry of folks to try to come up with that type of blocking technology because I'm sure they're assuming it would be a lucrative invention. So nothing I'm aware of out there right now. I'm not sure what it would do. When they say robocalls, I think of pre-recorded messages, but it certainly has been used in the past to use to talk about predictive dialers as well.
Okay, so it's 1:30. It's 2 o'clock, so you can turn it over to your
Thanks, Stuart.
next webinar. Okay.
Take care, everybody.
Thanks, everybody, for taking participation in this.